The next thing we are going to see is the Geneva Convention Awards. These are two conventions, right? New York Convention and the second one is Geneva Convention. New York Convention is given under Chapter 1 of Part 2 of the Arbitration Act. This is the Chapter 2 of Part 2 of the Arbitration Act. This is very similar to the New York Convention, except at some places where you have to concentrate a little bit to understand this. This is very easy. Now we can get into the chapter. The first section which we are going to see under the Geneva Convention is section number 53. In this chapter, foreign award means an arbitral award. By this what we can understand is that for foreign award under section 44 a definition was given, and under section 53 also a definition is being given. So section 44 definition will apply to New York Convention chapter 1. The section 53 definition will apply to Geneva Convention chapter 2. This is the thing we have to understand by this line. This is also similar to the section 44 definition. It should be an award on the differences considered as commercial, and it should be made after this date. Like that is also same as section 44. In pursuance of an agreement, here also they are mentioning the arbitration agreement. Arbitration agreement should be made, and for that the second schedule convention should apply. That is, the Geneva Convention should be applicable to the arbitration agreement. And here, this is by reading this we will be wasting time, so we can directly read the explanation. This is a not so important section. So here according to section 53, government by notification has to declare the territories to which the Geneva Convention would be applied. Same like that the government will declare for what are all the outside India territories the Geneva Convention will apply. If the award is made in such territory which are not the parties to Geneva Convention, chapter 2 will not apply. If the award is made in a country where Geneva Convention will not apply, then that award cannot be enforced under chapter 2. Now, if a foreign award will not be considered final if any proceeding in respect of validity is pending in the country. The award is being made in a foreign country, then only it is called a foreign award. If any proceeding, any court case or something like that is pending in the foreign country regarding the validity of the award, whether it is final or not, like that there is any proceeding pending. Now, that award will not be considered as a final award. We should wait for the outcome of that proceeding. Only then we can enforce it under this law. In simple words, if you want to understand this section briefly, there should be an arbitration agreement for which the Geneva Convention applies. The award should be made according to the foreign laws. It should be made in a territory outside India. For that outside India territory, the Geneva Convention should apply, and then the award should be final. There should be no proceeding pending relating to the finality of the award. These are the 4 pointers given under the section 40. These are the 4 final points given under section number 53. The next section we are going to see is section number 54, power of judicial authority to refer the parties to the arbitration. Same like that we have some pointers here. These are the condition for the judicial authority to refer to arbitration. There should be a dispute for which section 53 applies. Okay, there should be a dispute. Second one is that there should be an arbitration agreement. Okay, the third point is there must be an application to refer to arbitration by any party. Any party to the arbitration, they should make an application that I have to solve the dispute through arbitration, do not take up the case. Like that, there should be an application to refer to arbitration. Then the judicial authority thinks that the arbitration agreement can proceed and is operative. The arbitration agreement should be operative. It cannot be invalid. Then the next point is the judicial authority must be satisfied that the arbitration is valid under section 53. First thing, there should be a dispute. Second thing, there should be an arbitration agreement. Third thing, there should be an application to refer to arbitration. Fourth thing, arbitration agreement should be operative. Fifth thing is that the arbitration should be valid under section 53. These are the 5 points. If these are satisfied, the judicial authority shall transfer the case to arbitration. One more point is that this is a notwithstanding provision. Notwithstanding anything contained in part 1 or in the Code of Civil Procedure. Now, this is a notwithstanding condition. That means that this section number 54 is superior. Only this will prevail even anything contrary is given in part 1 or Code of Civil Procedure. For example, something is given in section number 54 and something opposite is given in part 1 or Code of Civil Procedure. Now what you will follow? Whether you will follow the part 1 or Civil Procedure or you will follow section number 54. Here, since it is a notwithstanding provision, you have to follow section number 54. This is the main point here. And then these are the 5 pointers which should be satisfied for referring the parties to arbitration. The next section is section number 55, foreign award when binding. When the foreign award will be binding, for what all the purpose the award will be considered binding. This is given under this section. It will be acting as a binding force upon the parties. For what all the purpose, for seeking defense set off or any legal proceedings, you can take this award as a binding award. The next thing is evidence section. Same like New York Convention, here also we need evidence to prove that it is a foreign award. For enforcement, we have to give to the court the evidence. What are all the evidence? Original award or duly certified copy, and evidence proving that the award is final, and evidence, such other evidence as may be necessary. And where any document requiring to be produced is in a foreign language, you should give a translation. That is given here also. Original award, proof it is final, and such other extra evidence. This will allow the court will allow the party to fulfill above conditions even when during the proceedings. Even after making the application, you can fulfill the conditions. That point also is also given here. Diplomatic or consular agent should authenticate the translated copy. That point is also here. This is very much similar to the New York Convention. The next section is conditions for enforcement of foreign awards. Same like that we have saw section in the New York Convention. Here, for enforcing the foreign award, what are all the conditions to be fulfilled? The award should be in pursuance of a submission to arbitration, which is valid. There should be a valid arbitration for the award to be enforced. Subject matter should be capable of settlement by arbitration. It should not be a matter which cannot be settled by arbitration. Then, the award has been made by the arbitral tribunal, which has been constituted in the manner agreed upon by the parties. The arbitration tribunal, the composition is questioned here. The composition should be according to the agreement or according to the law. It should be in the manner agreed upon, or it should be in conformity with the law. The next point is, the award has become final in the country. In the foreign country, the award is final. There will be no proceeding pending regarding the finality of the award. Enforcement is not contrary to the public policy. Same like that, for checking public policy, what you will do, whether it is fraud or corruption, you will check. Then you will check the fundamental policy of Indian law. Then you will check the basic notion of morality, whether it is against all this. If any one of this is satisfied, then we can say that it is contrary to the public policy. For avoidance of doubt, whether there is a fundamental policy breach or not, for that you should not make a review on the merit of the dispute. You should not go into the details. You should check only the award. Next point is, for the first point, the party should furnish the proof. And here, even if the court is satisfied, you need not furnish any proof. For the court will itself suo motu, it will take a decision to not enforce the award. What are all the reasons? Award has been annulled in the country. That means it is cancelled. The country in which it is made, the award is cancelled. Party against whom it is sought. The unfavorable party we saw right in the New York Convention. That party was not given proper notice. He was not given sufficient time to present the case. He was under a legal incapacity. Same reasons for the unfavorable party. Award does not deal with differences contemplated or falling within the terms of the arbitration. Award contains decisions beyond the scope of the arbitration. Same like that, award contains beyond scope decision. Then also the court can refuse the enforcement of the award. Now here there is a proviso. For example, you have submitted 5 issues to arbitration and we got an arbitral award. In that only 4 decisions are covered. One problem, no decision has been given. Now in that case what the court will do is that it will postpone the enforcement of the award and it will do the necessary things which should be done. It should postpone the enforcement and grant it subject to such guarantee as the court may decide. The court will decide what to be done. Now here we have another point, subsection 3. Here what they are telling is that above we have told so many grounds. The court should identify by itself, the party should furnish the proof. Like that we have many grounds. But other than those grounds, the unfavorable party proves to the court that there is a ground other than the ground specified. For that, contesting the validity. On that ground, I can contest the validity of the award. Like that, the unfavorable party is saying. Now, what the court can do? It can give time to the unfavorable party to prove this to the arbitral tribunal. The tribunal which gave this award, unfavorable party has to prove the ground to the tribunal, and he should get the cancellation of the award from the tribunal. After hearing the ground, the tribunal what will do? It will cancel the award. This is given under subsection 3. The simple thing is, if there is any other ground upon which you can refuse the enforcement other than this section, you should go to the tribunal and you should tell the ground. The tribunal, if it accepts it, it will give for the cancellation of the award. The next section is section number 58, enforcement of foreign award. Where the foreign award is enforceable under this chapter, it shall be deemed to be a decree of the court. Same as the New York Convention, if the award is enforceable, it will be considered as a court order. Appealable orders. An appeal shall lie from the order refusing to refer the parties to arbitration or enforce a foreign award under section 57 to the court authorized by law to hear appeals from such order. For example, if a court is not referring you to arbitration under section 54, or a court is not setting aside an award or refusing the enforcement under section 57, under these sections you can go for an appeal. For a court which is authorized to hear the appeals. No second appeal shall lie. Only one appeal you can go, but this section does not take away any right to appeal to the Supreme Court. Same as the New York Convention. This is the last section of the Geneva Convention Awards, saving. Nothing in this chapter shall prejudice any rights which would have had of enforcing in India of any award or of availing himself if this chapter had not been enacted. Some parties will have certain rights before the commencement of this act. By commencement of this act, those rights are not affected. That is given in this section. This is not so important, but I am reading this once for your clarity. This is the end of the Geneva Convention. We have completed the entire New York Convention, Geneva Convention, and before that we saw the types of arbitral awards, types of arbitration, everything we saw. This chapter does not have so much weightage as the conciliation. It has a very low weightage when compared to the fundamentals chapter or the conciliation chapter. But still, if there are questions coming from this, you can easily tackle. Since the New York Convention and the Geneva Convention are very similar, you have to remember only certain conditions, either for the refusing for enforcement or for appealable orders. It is very easy to remember this. If you remember this one time, you can easily crack the questions and you can complete the test very easily. All the best for your SPOM Set C exams. I will look forward to your results. Please share your results in the comment section when you complete the exams. Thank you.